Well, good afternoon, everyone. This is Les Smith. I'm with the Michigan Department of Environment, Great Lakes, and Energy. It's my pleasure to welcome you all this afternoon to the discussion that we're going to have today about the PFAS criteria statutory and rulemaking process. This is the first part of the two-part discussion. Before we get into the webinar, I just want to go over a couple of housekeeping information for you. Before we bring on our presenter, I just want to let you all know that your lines are muted. You may type questions concerning today's discussion in the question box in the control panel, in the webinar control panel for you. And I just want to let you know that we are recording the webinar for future viewing. And with that, I'm just going to stall a little bit here. We have a number of attendees on the webinar today. We have somewhere around 140 folks registered for the discussion today. So just kind of stall just a little bit for some more folks to join us. While we're doing that, I'd like to introduce Mr. Joshua Mosier. He is the Assistant Division Director for EGLE's Remediation and Redevelopment Division, and he will be our guest speaker for the hour. Josh, if you are ready to go ahead and share your screen, I'm going to toss the virtual microphone to you.
Thank you, Les. Welcome, everyone. Hi, this is Joshua Mosier, as Les said, Assistant Division Director for RRD in EGLE. Today, we'll be discussing the process to establish groundwater cleanup criteria when there are no established criteria for a hazardous substance under Part 201, which is the Environmental Remediation Statute. So why are we here and why are we talking about this? So as we know, on August 3rd of this year in 2020, the state promulgated drinking water standards for 7 PFAS constituents under the Safe Drinking Water Act. They're listed here, and only PFOA and PFOS had Part 201 criteria, and the other 5 substances do not. So this is the regulatory process to develop criteria when there are no generic criteria in place. So we'll go through each step of the process in more detail throughout the presentation. This gives you a good outlook at this process from beginning to end. What is not in the required process are these information sessions. So we're going to hold these 2 information sessions to provide additional public participation and opportunity to learn, ask questions, and understand the process better. There will be a question and answer session at the end of the presentation. And today's presentation is going to focus on the process and your understanding of the process. We'll have the second information session and the ability to ask specific questions about the criteria, how the criteria were developed, and what the results were at that time. But we're going to focus, again, just on the process today. So the first step in the process under Part 201 is the department has to make a determination that these are hazardous substances. And we basically already have done that with the promulgation of the MCLs and the adoption of those. The department has already made that determination. But here's the statutory requirement under Part 201 as it pertains to the cleanup criteria. So this is the next step. In order to calculate generic criteria, the department's required to follow Section 20120A, 3A, and B of Part 201 and its associated rules and other requirements. So what's involved in that? Well, first, we must follow a specific order of preference as defined by the statute to determine a toxicity value. Then we go on to determine the chemical and physical data that is needed. And then we calculate the generic criteria in accordance with the rules. So under our rules, once we have all the information regarding the inputs, the toxicity, chemical, physical data, and assumptions, we have to do some calculations. We must use the algorithms provided in Part 201 cleanup criteria rules to calculate the criteria. So under Rule 10.3, you'll also see that this rule contains language pertaining to when a state drinking water standard is available, which is obviously pertinent to our current situation. And we'll have more on that in a moment. So these are the equations that are laid out in the rules. There's one for carcinogenic effects. There's also a rule for non-carcinogens. So the equation we use depends upon the toxicity value that is selected as part of the process and what toxic effect that value is based on. So after we do the calculations using the algorithms and come up with a number or value or concentration, we have to look again at the statutory provisions. And 20120A5 is a pertinent statutory provision when you're talking about groundwater in an aquifer. And it's an important provision, and it's consistent with the rule that we saw earlier. And this is where Part 201 directs the department on how to consider the calculated value in comparison to the other standards or criteria that may be out there. The first being a state drinking water standard. The second being a national secondary drinking water standard. And the third being an aesthetic value. And the most important part of this provision is it says, if our calculated cleanup criterion differs from either one of these three values when available, the cleanup criterion shall be the most stringent of one of these three values. So why is that important today? Well, that's important because the only thing that is available to compare to are the state drinking water standards for these PFAS constituents that were promulgated in August of 2020. So we have to look to this provision of the statute and to Rule 299.10.3 to determine the appropriate criterion for the hazardous substance. So as we're going through the process to do that, we'll do the calculations, and then we're going to take a pause. We're going to have a second information session before we move on in the process. So we're going to hold the second information session. During this session, we're going to show you our work. You're going to be able to look at the toxicity values that we selected and how we selected them under the statute. We're going to show you the calculations, what the numbers we came up with were. Again, we'll go through 20A5 in the rule to determine what ends up as the groundwater criteria. And then we're going to provide a comment period for people to submit written comments regarding the process and how RRD followed the process and regulations under Part 201 to come up with the resulting criteria. Then we're going to review and consider those comments prior to publishing and promulgating any enforceable groundwater cleanup criteria. So it'll be an opportunity for you to weigh in, give us your thoughts, your comments on how we follow the process. So after that process is over and we make any revisions if determined to be necessary, the next step in the process is to revise the rules, specifically updating the cleanup criteria tables, any associated footnotes, and any toxicity or ChemPhys data as appropriate, and then publish them. So here's a basic example of what it would look like. So we'd update the criteria table, publish them on our website, and send out an announcement. So here's the statutory provision in 201-2823 that drives this process. So within 30 days after publishing new generic cleanup criteria, the statute directs us to initiate a rulemaking process to promulgate rules for the new criteria. So we'll initiate this rulemaking process by submitting a request for rulemaking to the Michigan Office of Administrative Hearing and Rules. But there's one thing to note, and this is a very critical component, is that the criteria that we publish under this section of the statute is effective at the time it's published and legally enforceable at that time, until one of these three things happens. It's replaced by a final promulgated rule, the department withdraws the rule, or the time limitation in the Administrative Procedures Act process is not met. So again, the criteria become effective and enforceable upon EGLE's publication of the criteria. But again, we have to initiate the rulemaking process within 30 days of publishing those criteria. So what's the rule promulgation process look like? Generally, it looks like this. You submit your request for rulemaking, draft up your rules, submit your draft rules. And again, there is a public hearing process. There's a public comment process, so people will be able to comment again on EGLE's implementation of the process and the results. They'll go to the Environmental Rules Committee for review. And then if it goes through all that, it goes to the Joint Committee on Administrative Rules in the legislature. Once it goes through that process, it's then submitted for final promulgation. That basically ends the presentation for today. Again, this was just an overview of the process that RRD is going to undertake to establish criteria for the PFAS constituents that do not currently have established criteria. We currently do have criteria for PFOA and PFOS. I will go back to the beginning really quick. It was 70 parts per trillion, but with the promulgation of the drinking water standards, the Part 201 groundwater cleanup standard for PFOA is 8 parts per trillion, and the groundwater cleanup standard for PFOS is 16 parts per trillion. And that was sent out in a separate announcement earlier. So we're really looking at those other 5 constituents to run through this process. And that takes us to the end of the presentation. We're now going to open it up for questions.
The first questions that we got were, will the PowerPoint be shared? or how can we get a copy?
That's a good question. We are recording this session. Les, can you speak to where this will be available?
Yes, when the conclusion of today's conversation, we'll have the recording closed captioned, and then it'll likely be posted on the Eagles YouTube channel initially, but we'll also look for additional locations to post for easy accessibility. I tossed it back. Oh, go ahead, Patty.
At this point, we don't have any more written questions. One just came through. Is the department considering the addition and or updating of any other?
No, not at this time. We're focusing on the 5 PFAS constituents for which there are promulgated MCL.
What is the anticipated length of time for this entire process?
So following this process, the earliest that we would be ready to publish any criteria would be in December sometime, mid-December. And then we, within 30 days, again, initiate the rulemaking process by mid-January. And then from there on, the rulemaking process lasts anywhere from months to a year, I think.
Will the publication of notice include not only the proposed standards, but also the agency's justification for them?
Yeah, that's a good question. So we just, as we will see in the second presentation, what the results of the process will be, our publication will include an explanation of how we got there, yes.
For PFOA and PFAS, does the MCL become the new groundwater cleanup criteria?
Yes, it does. That is effective already. As we just explained, the MCLs are currently the established criteria under Part 2. The 70 is no longer the criteria.
Once these are promulgated, will they be officially incorporated into Part 201? Would these compounds then be eligible for BEA coverage?
The simple answer is yes.
The current criteria published September 2020, which was the PFOA and PFAS, do not show volatilization to indoor air criteria for the PFAS family. One footnote does not volatilize, other says under evaluation or words to that effect. Do the PFAS compounds present a volatilization risk?
That I do not know. I do not have the answer to that today.
I don't understand the answer about the availability of the slides. It sounded like there would be a recorded version posted on YouTube, but what about posting the slides for downloading?
Yeah, we can post the slides as well, and we'll send out a notice when we do that.
Presumably, Eagle has calculated the new criteria. When will those be made available?
Those will be made available in our second information session on November 16th.
Is there any possibility of promulgating a total PFAS limit for some or all of the 7 compounds to be regulated, as many states at the federal government have already done?
You know, I don't know if I can answer that today. I guess it's something that the department could consider. So I would say that would be a good comment to submit during the written comment period for consideration.
And so will the 30-day public comment period begin when the draft values are made available?
Yes, after the November 16th information session, when we have the draft values, at that time, that will be the start of a 3-week public comment period.
And I believe that's the end of the comments we've received so far.
Well, yeah, I don't see any more questions coming in, Patty. And Josh, do you have any final thoughts, or do you have any final thoughts before we close out the webinar?
No, I do not. I just hope everybody got some beneficial information today. Again, we're just providing this additional public outreach so everybody understands what we're doing before, you know, there are official numbers put out there, and we don't want to surprise anybody. So again, we're gonna come back to you in a couple more weeks. We're gonna show you the work we did, what proposed criterion we're going to end up with in accordance with the calculations and the statutory and rule provisions, and provide a public comment period for Eagle to consider comments before we actually publish anything. So again, just not a required process, but something we thought was important so everybody understands where we're at with these PFAS constituents.
Patty, you want to take those questions?
I'm hoping you can help me with explaining that the session is being recorded and where people will be able to find it again.
Yes, this session, for those that came in later, we are recording this webinar, so we will post it initially on Eagle's YouTube channel, and then we'll find some place, we'll place it on remediation redevelopment page. I just don't know exactly where, but I know initially it will be on the YouTube channel. That's where folks can find that within the next day or so.
So we've got a few more coming in. Can you explain what the cleanup criteria applies to? Is it mainly brownfields?
The cleanup criterion will apply to any release of those PFAS substances that are found at those concentrations or greater in groundwater. So any site of contamination. So
Which
brownfields included.
Leads to the next question. Does Eagle know how many sites may be impacted by the 5 new criteria? Will that be addressed as an RIS, regulatory impact statement, with the formal rulemaking or earlier?
You know, I don't have that information in front of me, so I don't want to misspeak today, but we'll consider that going forward. I will tell you that most of the drivers are already the PFOA and PFAS. I can't say there won't be others affected by this new criteria, but.
And we got 3 comments in a row about questions in a row about will there be soil cleanup criteria associated with the drinking water criteria?
Not at this time. We are focusing on the threat to groundwater and establishing the groundwater cleanup criterion consistent with MCLs.
And the next question is, at the time the draft criteria made available, will Eagle make the calculation worksheets available at the same time, given the relatively short public comment period?
I'll have to check on that. So yes, we will consider that prior to the 16th.
And we had a question, what happens when federal criteria for PFAS are established?
So if those are established, when they're established, we have to look to the 201-20A5 of Part 201, and I'll go back to it really quick so we can see it in front of us. Oops. So we have to follow this part of the statute. And then these are in no particular order. The first thing is the state drinking water standard, a national secondary standard, which I understand is an aesthetic value, and C, there's not a national secondary standard, then it's the state aesthetic value. So what would happen is, and Patty, correct me here if I don't get this exactly correct, is that we would have to adopt the federal standard as the state drinking water standard for this provision to kick in. This provision of 201 doesn't directly require us to look at the federal standard, but I think typically when it's appropriate, we would adopt a federal standard if we didn't have a state standard, but we are out in front of this one, I guess, and have state standards to consider. So that's that would take primacy. So I believe we'd have to adopt the federal standards under the Michigan Safe Drinking Water Act in order to consider it under this process.
And I think that was correct.
Okay, thanks.
Will your groundwater criteria apply to the discharge of contaminated sites, cleanup, pump and treat system discharges to groundwater or surface water bodies? And I think if you want, I can answer that because there are water quality standards for PFAS and PFOA. There are not necessarily water quality standards for these five. And they don't. Our most recent interaction was there isn't sufficient information available to develop the water quality standards for them.
Okay, thanks.
And the next question was, are criteria for biosolids being developed yet?
At this point, there is a study going on, so it's premature to speak to that at this point.
Will the no stricter than federal standards come into play should federal government develop criteria?
Again, that'll be something that will have to be considered if and when that happens, and then how that affects, whether or not we adopt a federal standard. It's not, again, it's under the Safe Drinking Water Act and not necessarily under Part 201 that happens.
Okay, that's what has come in so far.
So just for a point of clarity, so people understand, so if you read this section of Part 201, it says if a cleanup criterion calculated for groundwater and aquifer differs from either A, B, or C. So just for clarity, it does not matter whether the calculated criterion is higher or lower than one of these three standards. It just has to be different. And if it is different, then the statute doesn't actually allow us to consider that value anymore. And we have to pick from one of these other three things if available. And it's the most stringent of one of these three. And the calculated criteria does not get put in the mix for consideration. So just keep that in mind when we get to session 2, and maybe the rationale for how we got to some endpoint is, this statutory directive is pretty straightforward. It just has to differ from, so higher or lower. So even if it's more stringent than one of these 3 other values, we still have to use the most stringent of these 3 other values and not the calculated value. It may elicit some more questions.
Yeah, well, I'm looking at the question box to see if there's any more coming in.
And I have none.
I have none.
Oh, give them a minute.
Patty, there's one for you.
Does that differ clause cause problems or void in control of PFAS?
I'm going to use a term you're probably going to hear tomorrow. It's too early to tell at this point. Referring to election results, by the way.
This
Patty,
is the first.
Oh, okay.
This is the
Go
first
ahead,
time
Patty.
Michigan. This is the
Sorry.
first time Michigan has had state MCLs that were not first promulgated by the federal government. What is the process for the state to consider the federal MCLs?
I do not know. Patty, do you have any insight into that?
I think you've already answered this when you said we would go back to the State Drinking Water Act to determine whether we have to adopt the federal, if and when there are federal standards, if we have to adopt those.
Yes, it would. I just don't know the specifics of what the considerations are under that.
And I don't know the
law.
State Drinking Water Act that well either. Based on the last statement, if the calculated value is different than the state MCL, you still need to use the MCL, correct?
Correct. If that's the most stringent of these 3, and again, those are the only, the state MCL is the only standard under this part of the law. So yes.
How does the state definition of hazardous substance differ from EPA classifying PFAS chemicals as hazardous substances?
That I do not know. I know that our definition includes anything that's on the CERCLA list, but as far as whether or not they include it on the CERCLA list as a hazardous substance, I'm not all that familiar.
Doesn't the response mean that Part 201, the Part 201 number will be the state MCL?
Well, if you take this verbatim, if it's higher or lower, it defaults to the MCL, and if our calculation ends up being the same, it's the same. So technically, yes. But we still have to follow our process. We still have to go through 20120A3 and do the calculations in accordance with that process to make this determination under 20A5.
I have no additional questions.
All right. If you don't have any more questions at this time, again,
Oh, there's
we will
one.
see. Oh, there's
There's
one. Okay.
one. Yeah. Sorry.
All right.
There is one.
I think it was more a statement than a question. EPA has
Okay.
not yet classified any PFAS as hazardous substance under CERCLA.
Okay. I see it.
And again, and if they do, then our definition already includes it. So.
All right, Josh, you have any closing comments or thoughts?
No, I just want to say thank you to everybody that took the time out to come and learn this process and learn about the next steps. Good questions. So I think you can see where this is going, but we will see you back here on November 16th. So you can see what we did to calculate cleanup criteria under Part 201 and the determination made in accordance with this provision of the statute. And yeah, give you the ability to comment on that as we move the process forward. So again, thank you very much, everyone.